29th, 2020 Zoning Board of Adjustments meeting.
Excuse me. Thank you.
The next zoning board meeting will be February 26th, 2020. I guess we'll just jump right into it. Everyone could stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Patrick, do you have the preamble by chance?
These are awesome chairs. Good evening, ladies and gentlemen. We proceed with the petitions in the order they are listed on the agenda unless the board deems it appropriate to take a petition out of order. State law and local ordinances set out criteria that must be met in order for this board to grant a request. The minimum requirements are outlined on the form provided by the Community Development Office, and the petitioner should proceed with this format to provide adequate justification for the board and grant the request. The chair will open the meeting to hear testimony either for or against the request. All discussions will be between the speaker and the board. Please be respectful of all and in the interest of time refrain from repeating your previous testimony. No new documentation will be accepted by the board for consideration this evening, but the board reserves the right to ask for additional testimony at any time. After the hearing the facts from all parties regarding the petition, after hearing all the facts from all the parties regarding the petition, the chairman will close the public hearing and the board will deliberate and vote on the request before moving on to the next petition. Please turn off all cell phones. Anybody that's going to be speaking at all tonight, please stand to be sworn in.
So anyone who will be speaking tonight at all, please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Right. Thank you. So before we get started, the first petitioner with the first three petitions has requested a continuation. So I'll read into their letter to us, which is, Dear Chairman and Board Members, for the above referenced applications, 3, are requesting continuation from the January 29th, 2020 to the February 26th, 2020 Zoning Board hearing to allow the applicant to meet with the DPW and staff to work through concerns that were raised to the applicant via phone call at 2:30 p.m. Today. K&A will be present to further discuss the variance at the February hearing. We thank you in advance for your consideration on this application. If you have any questions or comments, please contact, and then they provide a number, which I don't read that in, do I? Okay. So, and that's from Matthew Peterson, Senior Project Manager of Keach Nordstrom Associates. So what I'll go ahead and do is read in each of the variances, and then we will vote on continuation. So the first variance is Strife LLC, petitioner owner. Variance under section 3.02, note 6 of the zoning ordinance to permit the construction of a 3,000 square foot building 30 feet from the Daniel Webster Highway, whereas 50 feet is required. Parcel is located at 406 Daniel Webster Highway in the C2 General Commercial, Aquifer Conservation, and Elderly Housing Overlay Districts, Tax Map 5D-4, Lot 099, Case 2019-39, which was continued from the November 20th and the December 18th meetings. Do I hear a motion for continuation?
I'll move that we grant continuation on Strip LLC variance request under section 3.02. Will you read the whole thing? No. All right. I'll second.
Okay, motion made by Lynn, seconded by Kathy. All in favor?
Aye.
All against? All abstention? So 4-1-0. The second petition, Strife LLC, petitioner owner, variance under section 3.02 of the zoning ordinance to permit the construction of a retaining wall 10.88 feet from the front property line, whereas 30 feet is required. Parcels located at 406 Daniel Webster Highway in the C2 General Commercial, Aquifer Conservation, and Elderly Housing Overlay Districts. Tax Map 5D-4, Lot 099, Case 2019-40. This item is also continued from November 20th and December 18th meetings.
I'll make a motion to continue.
Okay.
I'll second. Either one.
Motion made by Rod, seconded by Lynn. All in favor?
Aye.
All against? So 410. Third petition, Strife LLC. Petitioner owner, special exception under section 2.02.3 C1 of the zoning ordinance to allow for a residential use in the C2 General Commercial District. Parcels located at 406 Daniel Webster Highway in the C2 General Commercial, Aquifer Conservation, and Elderly Housing Overlay Districts. Tax map 5D-4, lot 099, case 2019-41. Item is also continued from the November 20th and December 18th meetings.
Have a motion?
Okay, motion made by Kathy, seconded by Rod. All in favor? All against? So 320. Okay, now that we have that out of the way, the next petition is for Linda Raymond, petitioner owner, variance under section 3.02 of the zoning ordinance to permit a two-lot subdivision with one lot having 59.33 feet of frontage, whereas 250 feet is required. Parcels located at 107 Turkey Hill Road, in the R1 residential by soil and aquifer conservation districts. Tax map 4C, lot 229, case 2020-02.
Good evening. Attorney Greg Michael, along with Attorney Brett Allard, to present the Raymond case. As indicated by your chairman, the property is at 107 Turkey Hill Road. Is long enough. And the proposal, I'd like you to look at the kind of the green line on the map that was submitted with our plan. And if you look at the proposed subdivision line is the line that is right here, the first line heading northerly, which would separate the lots in question. The Raymond family has owned this parcel for well over 40 years. And in fact, they own these two pieces that you see here, which would be lots 230, 231. And in fact, they were the ones that subdivided these many years ago. And at the time, and this is kind of important, it was a 150-foot frontage requirement. So this lot, 231, 230 were conforming. And interestingly enough, they left 300 plus or minus feet here for the purpose at some point of subdividing the parcel off again. They didn't need to at that time. They didn't want to at that time. But the time has come to try and deal with this parcel. As you can see that the primary parcel map 4C 229-1 as it's shown, that will be a fully conforming lot by way of frontage and size. The second lot, which is map C 229-2, is a large lot. Large, it's I think that's 8.56 acres to remain. You can see it's very significant, encompasses the area that is shown on the map that I'm showing you. The problem, of course, is here, where you've got 59 plus or minus feet of frontage is shown. But really, the frontage in this instance is, in effect, not really germane to the reasonable use of this parcel. The proposal is to have a joint driveway, so there's not going to be another road cut. So as far as driving by and looking at another road cut, that isn't the plan. This will go to the planning board for their review. And again, it's a long driveway, and there are a number of long driveways in Merrimack taking you way out to I'll use the term, the rear of the parcel. And as you can see, this is a very treed area. Brett will discuss more about it. The proposed dwelling, the proposed well, septic, it meets all of the other standards for a single-family residential use. I want to make that clear. The only issue is the frontage issue, which again isn't that material. I would point out again that the plan was back in the day to subdivide this at some point, but of course Merrimack zoning rules have changed. We went to soil-based zonings. We increased various lot sizes and frontage requirements. And again, the purpose is important in this case. The purpose of frontage is generally not to have too many houses in any one area. In other words, the idea is not to have houses on top of houses. As you can see, this plan in no way, shape, or form proposes that, and I'm sure Brett will discuss that further with you. I've said it before and I'll say it again. Zoning is a big paintbrush. When you come in and say, okay, now we want 200 or 250 feet of frontage. The town, we don't microscopically, and I've been involved in a number of zoning changes in Merrimack over the years, we don't microscopically examine every parcel and every street and what people might or might not have done. We don't do that. Everybody does the best they can, and that's the purpose of this board. You're the ones who take a close look at the impact to these property rights. And, the only one good case on this frontage is Metzger versus Brentwood. And in that case, the Supreme Court said, according to the evidence, the plaintiffs in this case, it was a 200-foot requirement. They did not have 200 feet. There would be if they had 200 feet, there'd be no restriction on how far back they could build their house or how long a driveway they had. That's the case here. Usually, frontage requirements can be justified on the basis that they are a method of determining lot size to prevent overcrowding. Well, that really doesn't apply here. We've got a very large lot. We're not trying to squeeze the frontage and have a smaller lot. That's not the case here. And they went on to say, in the case before us, however, the size of the plaintiff's lot far exceeds the frontage requirement that existed as it related to the lot, and the 200-foot frontage requirement is not necessary to accomplish that end. The end being, of course, that you've got squished-in houses and overcrowding. You don't have that here. Basically, you're going to have 2 houses on over 12 acres of land, which is certainly not overcrowding by any standard. And the court went on to say when the restriction is applied, and we're familiar with this because these same principles have fast-forwarded to some other cases, and the court said when the restriction is applied to a particular piece is unnecessary to accomplish a legitimate public purpose, which this isn't, by the way, or the gain to the public is slight, you've heard about that before, but the harm to the citizen and his property is great. Again, these people did this with the idea that later they could take that 300 feet and divide it up. The exercise of the police power, that zoning, of course, becomes arbitrary and unreasonable, and this court will afford relief. Well, that's kind of a summation by the Supreme Court a few years back, and many of those same concepts appear today when you take a look at the Simplex case in 2001 and move forward to where we are. There's a greater sensitivity, I know, by the boards, by this board and other boards, to take a close look at exactly what we're dealing with and not to apply some hard and fast rule. If you don't have the frontage, you can't do anything. These folks, again, have owned this for a long time. When they created their subdivision, they created it with the idea and the firm principle that they could deal with it further in the future. But again, as we all know, zoning can change, and that's happened in this case. Those conclude my remarks. I'll let Brett take you through the elements. If he needs to, I'll move.
I have a question before
yeah,
you actually
sure.
get into that.
Go ahead.
So I'm looking at the map here, I'm looking at the diagram we have. Are there going to be further variances needed to actually put in the driveway in the house
No.
because in the septic because they look really close to the property line based upon what was provided to us?
No, we're not requesting any other variances. We intend the balance of this development, the one house development, to be conforming, to answer your question.
Is there any particular reason why they're only doing 50 feet of frontage? Is it where you got 250 feet, they don't split down the middle? I'm just curious if there's a reasoning behind it.
We felt that based upon the fact it would be a joint driveway,
Mm-hmm.
we'd keep one lot fully conforming, and we'd bring it in, because again, we were gonna use that joint driveway to access.
Okay.
Plenty of room to put the driveway in, plenty of room. In fact, 50 feet is the standard we use for putting in a town road, on a
Okay.
subdivision plan. So we got more than that.
Okay.
So we just felt that this was a better layout. Now, yeah, could we go back and carve it off? Yeah, we could, but is it really, to me, it's a distinction without a difference. And now you end up with, pardon me, with 2 non-conforming lots, not one, and the one that we're dealing with is a very large lot, and we feel it certainly can accomplish the goal of allowing reasonable use of the property.
I guess 59 seemed like a odd number to pick, I just.
But,
was
the
curious as to why.
Supreme Court in Metzger, I didn't read all of it, I'm not going to, it's not my purpose to parrot this case, but they looked at it and said, what's the purpose of frontage? As long as you can get into as long as you can have safe access, which this will be, by the way, safe access, As long as you have that, and you don't have it, you're not trying to squish houses in other words, create these smaller lots with less frontage than you need, you can picture it, I know we all can, then, you know, frontage is frontage. You don't really need a whole lot of frontage if the style and nature of the development conform to the goals of zoning, which is not to have squished in houses. That's basically the goal. That was always the goal. Anything else? I think I'll turn to Brett and let him kind of take you through the criteria. Thank you.
Good evening, Chairman, members of the board. I'll start with the public interest prong. Granting the variance would not be contrary to the public interest. The test that the courts use is whether granting the variance will change the essential character of the neighborhood or adversely affect public health and safety. Here we have a single-family residential use which is permitted, which is consistent with the environment of the neighborhood, which is all residential uses. We have less than 250 feet of frontage on the proposed lot, which is why we're asking for the variance, but this is an extremely non-conforming area if you look at the other lots around it. There are 24 abutters. We said for the record, we said 19 in the application. That didn't contemplate the ones across the street, but there are 24 abutters, and 24 abutter notices did go out. Of those 24 abutters, not one of those lots is conforming with respect to area, and maybe a handful of them are with respect to frontage, mostly the ones on corner lots. But the rest of them are not conforming with respect to frontage or area. So asking for a variance for less than 250 feet of frontage, creating a lot with less than 250 feet of frontage as permitted by the variance would not be inconsistent with the character of the neighborhood, would actually fit in with the character of the neighborhood. As Attorney Michael said, the purpose of frontage requirements is to prevent overcrowding and congested development. We have a very large lot here where that concern is simply not at issue. There is sufficient area for the proposed dwelling and the related infrastructure that would go along with it, along with the driveway. Any questions before I move on to the next criteria?
Any questions? Thank you.
Granting the variance would be consistent with the spirit of the ordinance. The courts have held in the case of Farrar v. Keene that this criteria is very closely related to the first criteria, so for purposes of brevity, I will incorporate by reference my comments with respect to the first criteria, and then only add that we are proposing a common access easement that 50 feet or so from Turkey Hill Road up the driveway will be a shared driveway, so we're not creating an alternative access. An additional curb cut on Turkey Hill Road is not at issue here.
Any questions? All right, number 3.
Substantial justice would be done by granting the variance. As this board knows, this one's the balancing test, weighing public rights and private rights, and the courts have held that any loss to the individual that is not outweighed by a gain to the general public is an injustice. Here, due to the unique shape of the lot, there's no other way to subdivide this 11-acre parcel without a frontage variance. As we said, even moving the lot line, it's going to need a frontage variance or two if we moved it one way or another. This way, we've kept it to one conforming lot, and the other with the request for the frontage variance. If this variance was denied, 8.5 acres of the whole 11-acre parcel would have to essentially remain vacant forever, and there's no gain to the public that outweighs the loss to the applicant in that scenario.
Any questions?
No. The way you phrased it. Never mind. I'm fine. Let it go.
I only have one question. I'm not sure if you can answer this. You'd mentioned earlier on that there were a lot of properties that are abutters where they did not meet the 250-foot requirement. Do you by chance know what the smallest frontage property is and what it's specifically the amount of feet of frontage, not which parcel is it?
No,
Let me just point out one thing. These are 150 here.
Okay.
Lots, you can, if you look, you can see that this is less, this is less, this probably is less, depending on how usually the frontage is where the access is. This has frontage on Bancroft Street as well. But if you take a look at some of these other lots, they're 150 or less. I mean, admittedly, now, there's one lot here, 233, if you run that down, has only got 50 or 60 feet on Turkey Hill Road. This chunk here, lot 233.
Oh, so there's another
yeah.
property with a similar.
It's, yeah, a little kind of a strip in on the tax map. That's
Okay.
not part of this subdivision, but it's kind of an interesting area, and you must remember, this was subdivided back when the lot sizes and frontages were very different. No different than when the Raymonds subdivided these lots. It was a different era, a different time. Therefore, this area is quite a bit different than other areas that have observed, any new subdivisions have observed the 100,000, 250 frontage requirement that most of the land in Merrimack needs. Thank you.
Thank you. So that was all.
The values of surrounding properties would not be diminished by granting the variance. As I said, this proposal is single-family residential, permitted use in the zone, consistent with the other residential uses in the neighborhood. This is a very densely wooded area. Most of this lot is wooded, and the proposed dwelling is set back more than 400 feet from the road. So we're talking about a pretty private development. This certainly isn't being plopped down right by the road, and the driveway is certainly long enough that it's set back that it's going to be a fairly private establishment back there. And then, as Attorney Michael said, if the variance is granted, this would have to go to the planning board. So to the extent there's any other concerns along the lines of impact on abutting properties, it would be evaluated by the planning board as well during subdivision approval.
Any questions from the board?
Looking at my map, which is the same as that, this is a 60-foot buffer that would be between,
That's a 60-foot, that's a 60-foot to here buffer,
right,
yes.
and that
And
is
then-
at this point heavily wooded?
Yes.
Thank you.
Literal enforcement of the ordinance would result in unnecessary hardship. There are special conditions of the property that distinguish it from others in the area. As we have said, this is an 8.5 acre lot, fully conforming with respect to area. The lot, the existing property has 309 total feet of frontage. Comparatively, comparing it to other properties in the area, as I said, 24 abutting lots in the area. Only one of those has more than 2 acres. Most are under 1 acre, more than half. And none of them are conforming with respect to area. And almost all are non-conforming with respect to frontage. As you'll actually see in the staff report that staff prepared, they noted that this property is irregularly shaped. It's a very unique shaped lot. There is no other lot in the area that is shaped even close to similar, even close to as similar as this one, and it's substantially larger than every other property in the area. So owing to those special considerations, special conditions relative to other properties in the area, there's no fair and substantial relationship between the purpose of frontage requirements and their application here to this property. And I think the substantial area of this property is the particularly important distinguishing factor when you're looking at a variance for a subdivision. As we've said, frontage is a way to ensure that you're not building on top of each other and that you have adequate area for a house. That's just simply not at issue here. Even if this board was to grant the variance, the harm that frontage requirements aim to protect against are not threatened. They're not at issue. And again, that's due to the substantial size of the dwelling and the lot's ability to adequately accommodate the home and the related infrastructure. And the last thing I would point out before I wrap up is that the Supreme Court actually addressed a very similar case, a very similar type of property in the case of Rancourt v. City of Manchester. And particularly when it came to the hardship in that case, the court affirmed the ZBA's issuance of a variance for 4 reasons. First, because the lot was located in a country setting, which we have here. The lot was larger than most of the surrounding lots, which we have here. There was a thick wooded buffer on the property, which we have here. And the lot was uniquely configured in that the rear portion of the lot was considerably larger than the front portion of the lot. And the Supreme Court upheld the zoning board's issuance of the variance in that case, and we would submit that almost identically describes this property, and therefore it suffers from an unnecessary hardship, and we would ask the board to grant the variance.
Thank you.
Any questions from the board before we move to the public hearing? Okay.
This may be too early in the process, but do you know what style of house is going to be built there and how many square footage, how many stories?
We're not sure, but we believe the lot would certainly support a nice-sized home. But in point of fact, you're not really going to see it. But I expect that with the value of land, that there'll be something that, decent built there. But no, there's been no discussion about that. The planning board may talk about it, but the purpose here is a frontage issue.
Any further questions? All right, I guess if that's where we're at, then I'd like to open up the public portion of this. Oh, sorry, Lenny?
Yeah, question, Patrick, are you straight on the septic system issue? Well, you would ask the question. They're depicting the septic system at 30 feet. Our zoning's 20, state regulation's 10. So,
Appreciate, yeah, no, I was looking at more like the house and it looked a little tighter than on this, but I kind of measured it out, so, yeah. I see what you're saying.
All right. So with that being said, I'd like to open up to the public. Is there anybody that would like to speak in favor of this petition? Is there anybody that would like to speak against this petition? All right. So one at a time, please, if you can. Take a seat. Make sure that you are writing down your name, stating your name.
This is my husband. Can we come up together?
Yeah, you go. That's fine. And you guys have both sworn in?
Yes.
All right, just make sure.
Okay. Mr. Chairperson and zoning board members,
Oh,
My
I'm sorry.
name-
Oh, yes.
my name is Deborah Utero, and this is my husband, Robert Utero, and our address is 5 Acacia Street in Merrimack. Mr. Chairperson and zoning board members, my husband Robert and I have lived at 5 Acacia Street for 40 years. As the closest rear abutters to the proposed location of a possible dwelling, my husband Robert and I are presenting an objection to the variance application based on the following 3 variance criteria. I believe you have my remarks. We brought them to the office and they made copies. However, when we go through, I am asking for permission to address some of the things that were discussed, like the lot being logged the past couple of years, and behind our house currently, it is not heavily wooded, it is brush. So is it all right if I mention that? Because
Oh,
that
absolutely.
was, okay,
You can address whatever you like. You just have to address the board when you do it. So,
okay. All right, here we go. So, according to the 3 variance criteria, first, I've combined variance criteria 1 and 2 since the courts have shown that these 2 variance criteria are related. So, variance 1, criteria 1 says, granting the variance would not be contrary to the public interest. And variance number 2 says, the spirit of the ordinance is observed. The proposed lot is not in the character of the other lots in the area. The other area lots are 1 to 2 acres, with the houses located near the front of the lots with short driveways. the proposed subdivision would result in one lot that is approximately 8.56 acres, and the other lot, 2.2 acres, with a shared 400-foot-long driveway with the house located in the higher ground at the rear of the property. Therefore, granting the variance will alter the essential residential character of the neighborhood, and the spirit of the ordinance would not be observed. Secondly, and this is variance criteria number 4, the values of the surrounding properties will not be diminished, is how the criteria reads. And I am going to quote from page 2 of the attachment to the variance application. So it says, quote, "There will be substantial distance between proposed dwelling and dwellings on abutting properties. The proposed dwelling is set back more than 400 feet from Turkey Hill Road. Therefore, surrounding property values will not be diminished," end quote. Our 5 Acacia Street property abuts the property from the rear. Since the building guideline is 60 feet from the property line, while the proposed dwelling may not be placed near Turkey Hill Road, it may be placed close to our lot line, in fact, 60 feet. And I just wanted to mention that the property behind our house was logged 2 years ago. And in fact, behind our house, which is behind the area in the diagram, which is on file in the office upstairs of the proposed dwelling, that area between our house and the area of the proposed dwelling is not heavily wooded currently. It was over 2 years ago, but then it was heavily logged, and now it's brush, basically. So that house would be very visible.
Completely, all the mature trees.
He's saying the entire 10 acres were logged, even very, very mature trees, 2 years ago.
And all the mature trees were removed at that time.
Okay.
Therefore, our property value will be diminished if this proposal is granted. In summary, the proposed subdivision does not meet 3 of the 5 variance criteria. Therefore, we are opposed to the proposal, and we ask the Zoning Board of Adjustment to carefully consider the negative impact of the subdivision on both our property and also on the surrounding neighborhood. And can I ask a follow-up question of the board?
Sure.
So, we were wondering if any of the members of the zoning board has had the opportunity to walk the land and actually see what is being discussed here tonight.
I haven't walked it, but I've been over there.
Okay.
Short of walking on to the property, and I haven't been on the Acacia side. I have gone onto the property a little bit.
On the Acacia side?
The Acacia side. I haven't been on the Acacia side, but I have been on the Turkey Hill side. Went up a little bit into the property, but I didn't see your side of it.
Okay, so that might be something that we might recommend, because so far we've been hearing a lot of the 400 feet and toward the Turkey Hill, I'm sorry. But it's equally important to hear about the conditions close to the rear abutters as well. So if I can respectfully ask that that be considered.
And if you were to walk around the Acacia Street side there, you'll clearly see from our property, everything is cleared back to the lot line. And then there's a couple of large shrub type of trees that are there. But if they were to put the home right there, you would be right in front of our backyard, and they'd be driving in the distance, 400 or 500 feet from right now Turkey Hill, driving all the way back through the woods and putting that house there. And right when the entire area was developed, they were homes that were built, whether it be Candy Lane, Northwood Drive, Acacia Street, Sarah Drive, Turkey Hill, the whole circle there had all of the homes on the perimeter with, like Debbie said, the driveways were right, within 50 feet to the road or whatever. There isn't one lot that goes in like that. You'd be putting one in right there, go in 400 feet, and it would abut the people on Acacia Street, us in particular, starting with us, and would have a negative impact on our values, and it doesn't conform to the existing structure of all of the housing that surrounds that area.
I believe the criteria says the character of the
Character
neighborhood.
of the neighborhood.
The only thing that I just want to point out is that what we're considering as a board is whether or not the 59 square feet of frontage is acceptable. So if they were to keep the property and erect a different structure back there, they wouldn't be in front of us and they'd still have something up against your property. So I completely understand where you're coming from. I just want to make sure that when we're discussing this, we're discussing the fact that we're looking at the frontage as what we're determining as a criteria for whether or not this is acceptable. As earlier you may have heard me asking about frontages of other properties. That's what we're really looking to weigh in on. How does this compare to the frontages of properties around it? So I completely understand where you're coming from. It's just that's the criteria we're looking at.
If the people that own that property now, if they took the existing driveway and they extended it back 50, 60 feet without splitting the property, they could still build a house there. They could build a barn there. They could build whatever they want as long as it was within the proper lines of borders and setbacks of, exactly, Lynn, of that. I understand, so because some of what you're getting into is a little bit more would be a little bit more on the planning board side of it. When you talk about style of house and things like that, that's becomes a little more planning board, which it can get mired and mirrored a little bit in the zoning side of things, but it's really not an area for us to make that call on. That's actually the planning.
But the 60-foot setback was discussed earlier here as well.
Yeah.
So that's why I addressed it.
Okay.
And also the criteria.
Question was asked.
Well, the question was
criteria.
asked about it was asked about what the buffer looked like or
Right.
what it was. But again, I think that the question was asked, but it's really, it doesn't have as much relevance as it does the frontage itself. I understand, again. So yeah, I'm just trying to reiterate what Rich was saying. Some of the questions and some of what you're proposing is a little more on the planning side. Lynn is
Right.
actually probably knows a little bit more on the planning side than I do about it, but
But they relate to the variance criteria.
Exactly.
Everything
And a
I've
400-foot
stated-
road is clearly out of the realm of,
okay.
Everything
the
I've
character
stated
of,
is in relation to the 5 variance criteria that were prepared for this case.
and that's all related to the road frontage, because that's where it starts. And then they're talking about the 400 feet going in, so certainly the variance criteria that Debbie pointed out comes into play.
No, that's absolutely true. The point that I was trying to make was that if we were to deny this variance, they can still build something right there. It doesn't slow them down at all. This is just whether or not the 59 square feet is appropriate or not.
Yeah, but there's a big difference between 400 feet and putting a house, like the other houses are in Turkey Hill, if I'm understanding you correctly. Then from a criteria standpoint, you'd be talking, a different situation.
Oh, I mean,
It's not within the character of the
Yeah,
neighborhood.
then it would be within the
And-
character.
and that's right
and
in the
spirit of
criteria.
of the neighborhood of everyone around. So that would be something totally different. But right now, as they're proposing right now, to subdivide and the frontage, it's creating right now a situation by doing that and allowing 400 feet in, that very, very clearly, in our opinion, that's not conforming.
sorry, Lynn?
Actually, we're not talking about 400 feet in. We're talking about 59, little over 59 feet of frontage.
Now, I'm talking 400 feet of a driveway going in.
I understand,
Yeah.
but that's not our criteria, and that's not our concern. What we're talking about is almost 60 feet of frontage for this particular lot, regardless of what the lot is. And it is very, very similar to 2 lots down. It is the same thing. It is a very large lot with a 50-foot, little smaller, frontage on Turkey Hill Road. So there is some criteria for similarity. I understand that it's not like Acacia, where you've got a little square lot with a house, less frontage than this particular one, less frontage than you couldn't build that now, because you were required to have more frontage than what you have now. But it obviously is not a nice circular road with a lot of little postage stamp houses on it, so it is different. But we're talking about this, really only this, just barely under 60 feet of frontage, and can we grant them a subdivision with just that frontage? And when I look and compare that to this lot, which is just down to, it is very similar.
But does the lot down two have a driveway that goes in 300 or 400 feet?
I don't care how far in it goes. It's got a long drive. I can't tell you how, because I haven't measured it. But it does have a long drive, and it has less frontage than they are asking for here. So it's just, I understand the rest of it. But that particular item, there is some similarity to the neighborhood on Turkey Hill Road.
I understand your concerns. However, sir, I understand your concerns. But to reiterate what Lynn was saying, what's in front of this board tonight is the frontage variance only.
Okay.
In section 4, it says, if the variance is granted, the applicant will be required to seek subdivision approval from the planning board,
Right.
which will ensure any improvements to proposed lot 4C229-2 will not diminish the surrounding property values. That's where you need to go.
Okay.
Right now, we're just talking about, can we approve the frontage? After that, it moves over to planning board. Not that I'm trying to dump it on them, but that's where
Okay.
your argument needs to be made.
So if that is the case, why did we run through all of the various criteria, the 5 there, as part of this decision-making? And we came back with our concerns and what we thought, was not in
Your concerns are very valid. But what's in front of this board tonight is a variance for frontage, not a variance for what's gonna be built in the back, not a variance for anything else, but can we approve the frontage where I believe 150 feet is required? And we only have
250.
250, and we only have 59. That's all that's in front of this board tonight. I understand, zoning and planning do walk hand in hand sometimes, but sometimes we don't. Sometimes it's purely zoning, and then it goes over to planning, and sometimes it comes back to zoning. But that's what this board is addressing tonight. Your concerns are legitimate and should be heard.
But aren't they part of the zoning application that was put together for tonight?
They're not part of the frontage issue, which is all that we're addressing.
If I may add, I think that part of the confusion in this is that they don't really have to tell us what they're going to build or where they're going to build it. As a matter of fact, maybe in some cases it's better that we don't know that, because it just kind of it's too much information. It's hard for us because we have to evaluate explicitly what's in front of us. And if a petitioner decides to provide additional information on what they're going to be doing with the property, we can't base our decision or our judgments around the additional information. We can only base it in front of the actual event, which in this case is the 59 square feet frontage. So whether they put the house on the left side of the property or on the right side of the property, that's not even something we can evaluate.
And the other thing is where, number 4, it says the values of surrounding properties will not be diminished. That's just based upon the frontage. That's not based upon what they build. It's not based upon how long the driveway is. It's it's based upon the frontage. And the argument that they came is that what they're looking for is 59 feet of frontage. And there's a home two rows down or 2 lots down that has the same amount of frontage. So when you're looking at things like unnecessary hardship, or unnecessary hardship is based upon just the frontage, not, and that's what we take a look at, when we're looking at granting a variance public interest. Again, it's about the 50 feet, it's about the frontage. And I could see, and it can get confusing, because then you start to think of, then, what are they building there and all that. That's where the privy goes in the planning. I'd love it for it to be combined, where we can make a call on all of it. Unfortunately, we have to look at just that property line. So,
The treed sections and the buffers, those all come into play at the planning board, because now
Okay.
we're talking about site,
All right,
not just
okay.
the driveway, but all of this area becomes, and now the frontage on the road doesn't affect you because you're way over here.
Correct.
If you go down Turkey Hill Road, you look and see this and this and this and this and this. That's what it's related to. Now, when they go to planning board, they're gonna say, what about the rest of this?
Okay.
And that's where this is gonna come into play. No idea, and I'm gonna make no promises as to what they will do, but that's where that would come into play.
But the frontage opens up the gates for, on the design plan there, for the proposed lot. So, from my understanding, to have it said that the frontage has no bearing,
Well,
on that,
the
but to me,
proposed lot,
it has an enormous bearing.
well, the proposed lot is there.
Yeah,
That lot is, the whole thing is there now.
yeah.
We're just saying, can we cut a road, essentially, private, with only 60 feet of frontage? That's all we're talking about, not the rest of this.
I guess what I still don't understand is, as part of the application here today, attached to it, and what was mentioned by the individuals before us, is a supporting of the following variance criteria. Okay, and we came back with our view on that and the reasons why, and why isn't that taken into consideration in granting the,
It could be that a lot of what they said before is not necessarily related to this frontage issue. It's part of their general presentation.
but it's still part of the application
Yeah.
for that.
And your testimony is also part of that.
All right, so the testimony regarding that is not part of the consideration in granting the variance for the frontage?
Right.
Okay,
When we make in the consideration, we have to take into consideration if we're gonna vote for or against this.
Okay,
We take in all the testimony, whether, because you also wrote a letter.
yeah,
You're speaking,
Yeah.
we take all of that into consideration.
Okay.
We just haven't gotten to the point where we deliberate.
oh,
Okay.
okay,
all right.
okay,
Okay,
okay, understood,
all right.
okay,
Thank you.
okay.
Thanks for clarifying the difference
Thank you, everyone.
between
It's
zoning and
not clear.
planning.
Oh, no problem. It's pretty common. Thank you.
Thank
Okay,
you.
thank you.
Is there an opportunity to add my name to speak at this point?
Of course.
If you'd like to go ahead.
I'll wait.
Okay.
Let this gentleman go first.
All right.
No, you go right ahead, mister.
Hi,
Hello. And you've already been sworn in?
my name's yes.
Okay.
Can I go with him?
I don't have any of these papers and stuff.
It's all right. You don't need them.
I have never done this before, so
You won't be the first.
first time for everything,
Have you been
right?
sworn in?
I'm not sure. What do I do?
Did-
I said I wanted to speak.
You're fine.
Yeah, yeah, yeah.
Thereabouts. My impression of the truth.
One of the most trustworthy people in the neighborhood.
What do you call the person that's running right down the driveway? Is that in a butter too? The driveway's gonna be like right next to my
We're the
property.
neighbors.
Where the-
Where
Where are you?
they plan on putting
What's your
road or
address?
103,
I live right here. My picture
103
window is
Turkey
right
Hill.
here.
So you're right next to.
right next door. Yes.
My house is right here.
We need your address
Sure. I got it right
First.
here.
Both.
out loud.
Oh, for me to tell you? My name's Kevin Mulhern.
And I'm Jackie Mulhern. We live at 103 Turkey Hill.
Good.
Okay. Are both of your microphones lit up?
I've been living there for, I don't know where you want me to start. You want to ask me a question since
You
I
tell us
I
whatever
seen
you wanna-
these?
Oh no, this is
What do you want to tell us?
Okay. First of all, it isn't heavy wooded anymore. Can I go
Not
to
at
the,
all.
can I go to the,
Please point to your property on
sure.
So the only catch is you have to have a microphone so that,
Right here. This is my property right here.
Okay.
Okay.
As it stands right now, you can see this property from Turkey Hill Road right now. You can see this person on Arcadia. Are you at 5 Arcadia? Yes, we are. You can see that.
It's not
wait,
wooded
wait.
at all.
Just,
You need to sit in front of the mic
yeah, sure.
and talk.
Sure, I just wanted to let you know where I was from. I know my neighbor, I've known her for years. I'm up and down with this whole, well, see, it's the whole frontage. The frontage is 59 feet, but like the people before me said, it opens up to the frontage is what's gonna make the whole property. It tunnels in to a lot. As it stands at the moment, can you point out where the driveway is gonna go on this? No, I want someone to point it out to me, the way I pointed out the property to you.
Right here, look at,
It would be,
Sure.
look right here.
I think it would definitely decrease the value of our house if we had a road or driveway looking right out my picture window at it. You know, it would be hard
Where's my
to sell our house if we ever decided to.
So where's the edge of the driveway gonna go?
that's, and
This line
And I don't, I don't
From my property line?
want a street or a driveway right up to my property line either. You know, it's all wooded, well, some trees right there right now, but.
It's gonna be-
And what she's talking about, like they said, it's not wooded. She had all her trees cut down, it's all open.
Yeah, but that's her opportunity to do that.
Yeah.
you know?
She wanted to
It
make
was
money
wood
by
when we
selling
moved
the
here,
back.
you know, and now there's all the trees are down there. And the light comes in, which dries up the land back there a little bit. I guess that's one positive.
It's
At the
dried up the
moment-
wetlands,
Just let me
definitely.
finish, Doc. At the moment, there's right where the supposed driveway goes over there's a brook there, a water area, and there's supposed to be a culvert there. I mean, I've asked a couple of times to have it taken out, because what happens is the water backs up in the back. I have a garage towards 200. You want me to show you?
No, just
I have
this part.
200
Yeah,
feet
if you
from
just
the
explain it.
street. I have a garage way in the back that the town approved 30 years ago. Behind that, the water is starting to get more and more water every year. I sort of noticed it after the people cut the trees left. They left a lot of debris in front of the culvert right there, so the water's sort of backing up and gathering right there. I don't know if, when somebody puts another house back there, what's gonna be done as far as that goes, because I don't want that to be worse.
Planning board deals with drainage.
The pl-
Yep.
Planning board deals with drainage.
Yep. That will be addressed.
So, I know you mentioned to the people before me that it's all, the only thing this is about the frontage.
Yep.
Which is right out our picture window.
The two lots over from my end is much more than 50 feet apart.
Speak into the mic, because this is
Oh,
being taped.
Two, sorry. 2 lots over from the 59.6 foot spot you're trying to go in. 2 lots over is much bigger than 50 feet. You mentioned that it was 50 feet. It's not 50 feet. Mine's like 115, and then the next one,
That's 50 feet.
that's
This
one,
is yours.
2, there's another one, 3,
Yep.
4.
This lot
So-
here is a 50-foot right-of-way into it,
Into,
into this
who,
lot.
who lives there?
That's DuPont's.
Well, this is second.
She has misinformation,
Oh, the second.
which is why.
Yeah, that's, yeah. Because I was just, they said the second lot over has 50-foot of frontage, which is like the fourth over. And so I didn't know comparing frontages. See, a lot of this really doesn't matter to me, with the exceptions of who is gonna live in my backyard, you know? It could be, if it's a priest or a pope, okay, great, but nobody knows who's gonna live there, right? So I you know, seriously, if you know, you get someone who's living back there that,
What if somebody
you're gonna
moves in next door to you that you don't like?
then that's fine. They're already there. She already
I'm not
lives
gonna
there.
go there.
I already like it.
I'm just saying,
No,
that's
no,
not,
it's just, you know,
that's
it's
not
just
part of the
being here.
criteria.
I understand that. So you invited me here.
Yep.
For what reason?
To talk about whether that frontage has a detrimental effect on your property.
I'll tell you after they move there and how we get along. And if they, right
All
now,
right,
out
so-
I look out
So-
my picture window.
Just to bring,
Keep this
See, I look-
relevant.
I look out my picture window right now, in that little 59 feet of frontage in my picture window. Years ago, I've been living there for 32 years, and there's 5 vehicles sit right there, right now, in that 59 foot of frontage. They haven't moved for 6 months, but they're there, right? And I look at them, and they're in that 59 foot area. So what does that have to do
All right.
with?
So I get what you're saying.
I mean,
and
I don't know what the point of being here is if,
well, so what we're discussing, and what's really, I think, important to keep in mind is we're discussing whether or not 59 feet makes sense in the neighborhood. We're not discussing personal property. We're not discussing driveway, house, or placement of anything. We're legitimately only discussing the 59 square feet of frontage and whether or not that's appropriate on Turkey Hill given the other properties in its area. So when we're talking about surrounding property values, we're talking about Turkey Hill. When we're talking about the appropriateness of this variance, we're talking explicitly as to whether or not 59 square feet is good or bad. We're not talking about who's living there or what they're building. And that I think it's really important that we kind of address this because we're not the planning board. We're only here to talk about that one aspect.
okay, I have 110 feet. If you cut that in half, right, it's about 55. Could I split that in half and subdivide that? And
You can certainly fill out a variance and sit in front of us and talk about it. Yes.
so that could happen, right? If it
You
happened over
could
here,
certainly fill out a petition.
happened over here, then it's a possibility, right?
It absolutely is.
Okay.
That's actually why we're here.
All right, all right. I don't, you know, like I said, this is all fun and new to me because I've been there for 32 years and I've been living there, and it just, things change. 1 minute it's gonna be 5 houses with a condo complex, the next minute there's gonna be a house outside my picture window. So I just wanted to, before something happens, is somebody gonna send me something and let me know where the house is gonna be and everything else, the planning
You'll
board?
If it gets approved and goes to the planning board, you'll receive a notice of the planning board, and
Doesn't
at that
abutter.
time, you can attend those meetings. If it gets approved tonight.
Okay. So is there other steps that have to get approved, or it's just?
Yes.
Yeah.
We're all, the only one thing we're talking about the frontage.
Yeah,
That's it.
okay. I didn't even, okay, thank
No
you.
worries. Thank you. Is there anyone else that's looking to speak in regards to this petition?
She needs to be sworn.
And
I did not swear in.
okay, if you could raise your right hand, and you swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, whole truth, and nothing but the truth.
Thank you.
Which is exactly why I wanted to speak. I didn't come here tonight to speak. I wanted to listen only. My name is Becky Dupont. I currently live at 101 Turkey Hill Road.
Becky, would you sign?
Yes, thank you.
She's the lot that is that back one that also has that narrow driveway.
So that's exactly why I'd like to speak. As I said, I live at 101 Turkey Hill Road, but I'm also owner of 99 Turkey Hill Road. I'm sorry, 97, I lied, and I so told you I wouldn't. So it's 97 Turkey Hill Road, not 99, I apologize. It is the non-conforming lot that so many people are speaking about and are sharing misinformation. There's been a lot of misinformation that has been said. So I find it unfortunate that nobody has walked the property. Maybe Attorney Michael hasn't, maybe you folks haven't, maybe some of you have, maybe Attorney Michael has as well. But truth be told is, so I was granted a variance, and there's a couple of people here who were very helpful in making that happen back in maybe 2012. Our lot does not have a long driveway. Our lot, if we're speaking about our non-conforming lot here, and it may be listed under DuPont Revocable Trust instead of my name. I forget which property is in the trust, but so this lot here, the home isn't built back here. So when we came for the variance, we came with zero opposition from our neighbors. We came with multiple letters in hand with approval from our neighbors, from our abutters. Because we did all of the steps, that was a short driveway. We built the driveway in connection with our neighbor. We built a circle driveway. They were elderly. They were very happy to not have to back onto Turkey Hill Road any longer. So we built a driveway that came in and circled so they could have safe entrance, safe exit. My parents, who would be moving into the home we were building, would have safe entrance, safe exit, so that there would be no headlights that went into anyone's bay windows. We built the house up in that very small, not back, there is no long driveway. It doesn't sit back between the neighbors. We purposely built it in line with the roadway and the other homes, and conforming with the other homes. So when our neighbors sit in their homes, they don't see our house because it's in line with theirs. There are no windows on a garage side of the home next to us, and there is only an entrance and no windows, like a small little breezeway, mudroom, and no windows on the neighbors. So the headlights don't bother anyone at all. All of the abutters were in agreement, wrote letters to support us. So I think that's really important to know, that there is no long driveway. It is in line with all of the other homes. So just to clarify that misinformation, because while we're only talking about the frontage variance tonight, this does get documented. You are all listening and hearing, and you guys wear more than one, some of you guys wear more than one hat. Some of you also sit on the planning board.
I don't think anybody was talking or that it was a matter of where or how that house was built on the lot. I think they were just referencing, and there was only referencing the fact that it is also a smaller frontage. And that was it. Regardless of the house, the sign, all that, that's not.
No, I'm very sorry, Mr. Dwyer, but it was stated that there's a long driveway that goes in, and that's that house actually probably has the shortest driveway on that roadway, just to make that clear.
I referenced only.
And you walked the other property, I think you said, so that.
I didn't reference a driveway. I referenced
No,
only.
I'm sorry, if you go back to the notes, what I heard you said, there's a long driveway that goes in. That's incorrect.
No, she didn't. She just said that it was a.
Okay, we'll go back to the notes and read that later then. We'll move on from that. So the other information that was shared by the attorney was that it was a heavily wooded lot. That's actually incorrect. The lot was logged by Alex Jordan 2 years ago, and he was hired to clear cut the lot. Everything was clear cutted except for what was rotten, what he and Linda couldn't make money on. So that information is incorrect. If you were to walk that property today, we actually can no longer walk that property because it is all scrub brush. It's all pucka brush. There is no hemlock trees. There's no more shading or blinding. There's just no landscape there at all anymore. It's actually become a little bit, it's just not. Yeah, there's some water, there's some dust, it's not at all what the property used to be before logging. So I just wanted to clarify that it is not a heavily wooded lot. In regards mostly to the variance that we're talking about tonight, the road frontage, and again, I own that property that was granted a variance back in the day. But Linda's lot, so Attorney Michael had said that they are going to have a shared driveway, and I think he said, he could correct me if I'm wrong, that they will use the existing driveway that's there. That's a bit concerning to me because there's actually 2 driveways that are there. Perhaps on the plans, there's only one, but Linda for years has rented out that other where it's non-conforming, the 59 feet. That has been rented for years to a different tree company and currently to a man who lives over, I think on Acacia or whatever that street is out behind us, where he's parking several cars that he might work on or he's selling. I don't know if he has a used car business or he's a mechanic or something, but there's multiple cars that sit on that lot. And cars pull in and out of that second driveway all the time now. If you're talking about how it would, I think it was brought up like that it wouldn't diminish the property value or there would be no harm to the neighbors. While there's probably no harm to my property, I would tell you that the Mulherns who live, if you're looking at my house, they live on the left. They live at 103 Turkey Hill and they live next to those 2 driveways that are there. Their home is different than the rest of the homes in our neighborhood. We all go in a line. So my front windows look at Turkey Hill Road. So do most of my neighbors. Their bow windows, bay windows, all look at Turkey Hill Road. Kevin and Jackie Mulhern's property, their home runs sideways, correct. So they don't face Turkey Hill Road. They face those 2 driveways. So it would be a huge impact on their family room. They would be seeing more headlights and more traffic in and out. The other thing is that driveway is also on a very big corner. All of these years, we've had to change how the bus drops off or picks up the kids. There's been multiple accidents on that corner. Bancroft Street comes out where Linda's driveway is. So there's been many accidents. Probably the most recent one, maybe, I don't know, October? Yeah. I think the most recent one being in October. So there is impact on that corner. And that was one of the things when I was granted the variance, there's a corner coming the other way as well. That isn't as close. My driveway certainly isn't on a corner, but that was one of the reasons for that circle driveway was so that we could come away from the corner even more and have a safer exit. So while I'm not necessarily yet opposed or in agreement with the variance, I think that there's just some misinformation that needs to be documented. So that's what I have to share.
I thank you very much for that. And I mean, you do bring up some good points. I think what makes it kind of tough is that if they were here for a variance because they were trying to build their house or their driveway too close to some type of a setback, that would be very different. It would be a very different conversation. So I think that's what kind of makes this situation tough.
It absolutely makes it tough. And like I said, we came with letters from all of our abutters in support. And there were people who sat on this board then who were very helpful in, pointing out why it might not have been approved, but because the abutters all said, let's go for it, it was an easy decision. It really doesn't impact me, but I think it does impact a couple of the abutters significantly. So for that, I just wanted to clear up the misinformation.
All right. Thank you very much.
Thank you so much.
Is there anyone else looking to speak in favor or against this petition? All right, Attorney Michael.
Thank you, Mr. Chairman. Members, I'll be brief. I've listened attentively to the comments and also to the board, and I think the board clearly understands what we're doing. I just want to point out a couple of things. If we had 250 feet of frontage, there's nothing to stop us from putting the driveway right here. I think this, I don't mean to say that in the wrong way. My point is, you're right, it's a frontage issue, not a driveway issue or a house issue. There'd be nothing to stop us from putting a drive up here, building a large barn. Quite frankly, there's nothing to stop us from coming up and making a turn and putting the house here. I mean, there's any number, you're right, this isn't, we did our best to kind of give a schematic of what could be, how it would be done. And you're absolutely correct. We're dealing with the burden of frontage on the parcel, an 8-acre parcel. That's what we're dealing with. I've heard comments about possible drainage. Planning board will deal with that. I've heard comments about, buffering. Planning board would take a look at that. Regardless of whether it's wooded or not wooded, people have the right to cut on their land. And if our opinion of woods and theirs is different, we apologize. Everybody can have an opinion. But in point of fact, what we're required to do is meet the setbacks, and we will do that. Regardless of the trees or no tree, we will meet the setbacks. If the planning board believes that certain buffering is further needed, they will do it. If they believe there's certain drainage issues, they will do it. What we're talking about clearly and simply is the burden on this, what these people thought they could do years ago, the burden that continues on this parcel. Thank you.
All right, thank you. Any further discussion or?
We have another comment, please.
All right, we'll reopen the public hearing. Thank you. Absolutely. Oh, I didn't close it? Oh, my apologies.
Is it okay?
Yep, absolutely.
I just want to state that,
If you could just state it into the microphone.
I don't talk loud enough?
No, it's the
No, no,
mic
I'm-
picking up for home.
No, I just want to state, like Debbie and I said earlier, we've been here 40 years, so we've seen a lot with that land. Attorney Michael said they could build a house over here or whatever. I have great reservations. This here was a pond. We used to skate on it
Planning board.
many, many years ago. And then the
that's
town
okay.
decided to drain some of this underneath Turkey Hill towards Wildcat Falls. Okay? I mean, this pond here at that time was probably 3 or 4 feet deep. And then you have catch basins from Acacia Street that drain on the curve in Acacia Street that drain into this area. And there's an easement on my property here, the catch basins from across by the street. The water flows down from the hill on the other side as you go towards, what's the Sarah Drive that goes up over
Yes.
there. It flows down to the catch basin there. I got a catch basin on the corner of my lot, the easement, huge culvert, and that drains into there. So when Attorney Michaels says, pretty much you can pick and choose wherever you want to build here, there are going to be some issues, that are going to present themselves. So I just want to give a clearer picture from the experience of having lived there. I've seen the water, like another gentleman mentioned, the pond area here, before the town drained some of that, the water used to run under here, and there used to be a little bridge on the backside here that you'd have to go over. There wasn't a culvert, there was a bridge.
Okay, so,
And Guy Raymond. Okay.
yeah, I think what's
No,
kind
I'm just trying to, give a clearer picture of that as to what's going on with the.
no, understood. Yeah, no, Attorney Michael's point wasn't that that was another consideration for a house. His point was that it doesn't matter where the house goes. So
Right.
and, in terms of what we're evaluating, it's a valid point because, we could talk about all the hypotheticals as to what can go in that property, but at the end of the day, the only thing we're looking at is frontage. Now, again, planning board, these are all great discussions.
Right.
So, I think like Patrick said earlier, I would definitely encourage you, and Kathy also said, I would definitely encourage you guys to go to
Oh,
the
we'll be
planning board
there.
meeting that this comes up in.
Well, it hasn't been approved yet.
That's true. If it's approved,
If
it's approved, the planning board meeting that it's at, but I guess we'll deliberate and that's where we'll go from here.
Right, thank you.
Thank you.
Thank you. All right. So I'm now going to officially close the public session. Comments, motions from the board?
I'm worried it might set a precedent, my opinion.
Just out of
I don't
curiosity,
really
how
like the
so?
wording on granting it. I don't like the wording on substantial justice, and I don't necessarily agree with diminished value, but that's just my that's my take on it. I mean, I can get into more detail if you want, but, you know, it's,
I guess my only question is, you know, kind of what we've been saying the evening is that are those concerns related to the frontage or to the proposed use?
frontage.
Okay. So just I am genuinely curious, just given the frontages of other properties around it. What concerns do you have?
Well, the concern is the wording under substantial justice where it says, therefore, the loss of the applicant when balancing public, private rights outweighs the loss and injury of general public in granting the variance. I don't really think that that's the case. I don't think that the public would gain off of this. I don't think that, I mean, the only person who's going to gain off of this is them, not the public.
You could make that argument about any petition, though. I mean,
No, Rich, you asked me a question.
oh no, I'm sorry.
Hey, buddy. All right, you know, you don't have to agree with me. You asked me what I was thinking, so. You know, diminished values. I mean, I've been up there, saw the land, you know, it's, I don't, you know, definition of wooded, you know, but, you know, putting something like that up there, it's not necessarily like the rest of the properties. The house is going to set back further. I think that there could be some diminished values, but then again, maybe I'm just getting into planning at that point. So, that's my take on it.
Any further discussion from the board?
I'm looking at the GIS map, and I'm going back to the variance, the little slot there coming down to Turkey Hill that they're talking about, as well as Mr. DuPont's property, in that, according to the GIS map, the house was not built way back on that property. So she's right, there isn't a long driveway. But there is a house there that has only 50 feet of frontage on Turkey Hill, whereas all the other houses along there have 150 feet or more. So that one house does have less than the frontage that these guys are asking for. I don't care about the length of the driveway, I'm talking about the frontage itself. And if you look at the GIS map that you've got, no, there's no long driveway, but they still only have 50 feet of frontage in front of their house. And I think that's what we're talking about as far as relationship. What they've done to this lot already, trees, shrubs, clearing, cars. I wouldn't want to be living next to a house that had 5 cars parked in the driveway all the time, whether they moved or they didn't move, but that's not what we're talking about here. That's an existing situation. Having this at 59.33 feet isn't going to change that. I think the planning board might have something to say about it, but for what we're talking about now, I don't see that that's relevant.
Any further discussion, or do we have a motion?
I'll make a motion that we, here we are, that we grant the variance under section 3.02 of the zoning ordinance to permit a 2-lot subdivision with one lot having 59.33 feet of frontage, whereas 250 feet is required. The parcel is located at 107 Turkey Hill Road in the R1 Residential by Soils and Aquifer Conservation Districts. Tax map 4C, Lot 229, case number 2020-02.
Motion made by Lynn, seconded by Kathy.
This is subject to obtaining planning board approval for the proposed subdivision.
Okay. All in favor? All oppose? All abstention? So 401. And that is it. I would like to move approval of the minutes ahead of. Okay. All right.
It's right on the road, yes it is. No, you 100% said it was a long driveway.
No, I don't care about that. I'm saying,
Well, you denied it, but it's on the recording.
I
so
don't
we'll-
care. I don't
Well,
care.
you were wrong, and you're on the planning board, and
sorry,
that
I'm
scares
wrong.
me.
Is
it okay if I
can get a picture of this on one of the abutters?
Do you want it on recording?
No, no, no,
'Cause-
I'm just asking you to clarify for me. Never mind.
Thank you. You have misinformation and you're on the planning board, and that scares me.
You have an extra copy of that map? You have an extra copy of that map over in your file?
Oh, I would love one. That's okay. So it's more defined than the little one that I have that was sent out to us. Thank you.
I think I would save that for the discussion because you bring up a good point. And having taken those trainings, I think they are strongly encouraged.
Excuse me, the board actually, if you guys could just move on out, we have a couple other things we need to address. Thank you.
All right, so I guess then sticking with the agenda, discussion, action regarding other items. First and foremost, I wasn't trying to cut you off, Patrick. I apologize.
No, I know. I mean, it was, that was going a little sideways and off the rails, and that's why I kind of just told everybody that they have to move out. We're in a small space. It gets really, it was going off the rails, so.
I will say that this is, it's hard to take an objective look, especially when the petitioner decides to put irrelevant information in the packet. And I think, unfortunately, that's something that we saw tonight, is irrelevant information added, possibly so that it could be delivered to the planning board as well as the zoning board to print one piece of paper instead of two. Whatever the reason is, we did not need the excess information that was necessary for voting on this, and it really, I think, derailed the point of the vote. The only thing I have to say to that is that usually it's the other way around. Usually the petitioner's putting the right amount of information, and it's the abutters that are bringing in not relevant information. But I think in this case, there was a lot of things that did not need to be stated in the petition itself, which.
I mean, I was literally about ready to say, look, they could put a motocross track back there. There's nothing you can do. They could run motorbikes up and down there and quads, and there's nothing you can do. It's
Actually, I was going to go with circus animals. I was going to go with a Ferris wheel, as long as it's not separated.
As it's within code, yeah.
Yeah. But I think Ben brought up a good point. You want to repeat what you were mentioning?
Well, there is a bill that is before the state legislature, and I'm not sure, it's probably already had a public hearing, but my guess is a lot of municipalities were looking at it. The bill sets requirements on all cities and towns, whether they do it now or not, to provide or require a minimum amount set training for planning boards and zoning boards.
That's good.
Awesome.
They see something coming down the pipe.
That'd be great.
Nothing wrong with that.
I don't know if the thing that I was mentioning, I don't know if this is different from that, is that we do have the annual OEP meetings, and I've attended a few of them. I wish I had the time to go to them because they're all-day events. With small children, that doesn't tend to be very easy on the schedule. But you learn a lot, and the fact of the matter is that a lot of these RSAs that we have become dated, and so we have to take into account, what is good to have. Just because it's been in the books doesn't necessarily mean that it's particularly relevant.
When you say OEP, what's OEP?
What does the OEP
Office
say?
of Strategic Planning.
Yeah, it's not OSI.
Oh, they changed it. Okay.
The beginning of a professional planning and
Yep.
zoning boards?
Yep.
Well, no, because I think, and it makes sense that the legislation is there, because you're starting to see more and more zoning boards and planning boards that are getting suits. I mean, I read the New Hampshire Business Review. I read that almost on a daily basis, you know, and you'd be surprised, zoning boards, Portsmouth, Newfield, Concord, they're getting hit left and right with lawsuits, and
Pretty sure we've been hit as well.
and even us, you've been here longer than I have, and you know we've been pulled out to the carpet. So I think that it's getting to the point where that's a lot of liability on towns and cities, especially like a town of Merrimack that has to face a potential lawsuit. And so I think that they're looking to get that training in there. The only issue that I have is that at the core essence of those 5 criteria, it's all subjective. It is all subjective. And it is all just a matter of opinion. Like, you know, diminished value. How do you,
Not against
yeah.
some training. It's long and it's not the first step of never ending. And a lot of the small communities, the selectmen are the planning board, the selectmen are, you know.
Right. But I mean, you're just starting to see a lot more litigation. I literally, like I said, when I read the NHBR, I read that, and I at least once a month there's at least 2 articles about zoning boards in New Hampshire somewhere that, you know, usually in Portsmouth. Portsmouth is getting hit hard, but you somewhere that the you know, zoning board ruled on this, and you know it.
Well, it's the pressure on building out the remaining available land is a lot of communities.
Sure, yeah.
And, that's what's causing more of it. Because so much of the communities have whipped out so much of the available land.
I mean, yeah, and a lot of communities are trying to preserve a lot of that land to not get it built out.
Or you do what we do, clog Route 3 artery with, housing.
Alrighty then.
But we'll let us digress. All right.
All right.
Let's not digress.
Is it safe to move to the approval of minutes?
Yes, it is.
The minutes of Wednesday, September 18th as printed.
Second.
All right. All in favor?
Aye.
5-0-0. Motion made by Lynn, seconded by Patrick. Oh, I'm sorry. 4-0-1.
401.
You watched it on TV, that counts. That's what you did Christmas Eve.
Motion to adjourn.
Second.
All in favor?
Aye.
Aye.
Now that the meeting's over,